All right. Good afternoon, everyone. Thanks for coming today. Even though it's April Fool's Day, we do indeed have a lecture happening today. We weren't pulling your leg, and lunch as well. So there's that. My name is Tyler Castle. I'm the Associate Director of the Center for Citizenship and Constitutional Government. On behalf of the center, really delighted that you're here today. We've been looking forward to this event for quite a while, maybe since 2018. We were excited about having Professor Mark back with us. As some of you might know, if you've been following our events for a long time, Professor Mark was a visiting professor with the precursor to the Center for Citizenship and Constitutional Government back in 2017, 2018. And during that time, he did a bunch of work on this book, which is now published, which you'll hear more about today. So we're excited about this event, not only because, kind of self-serving, we're promoting this book, which was partly produced with the center's support, but it's also just a wonderful contribution to central issues in political theory, government. The subtitle, if you haven't seen it already, is Authority, Obligation, and the Common Good. If you just added rights on there, you'd have all of the key themes in political theory covered. So we're really delighted to have Professor Mark with us to give a lecture on a central topic to what we're focused on here at the center. As we usually do, I'm going to have welcome up a Tocqueville Fellow, a student, to introduce our speaker today. Christian Yerlekian is a senior, so he's got about a month left. He's a political science and Chinese major and a Con Studies minor, and he's from Los Angeles, California. So, Christian.
Dr. Danielle Mark is an assistant professor of political science at Villanova University, where he has taught political theory, American political thought, philosophy of law and politics, and religion since 2013. Beyond academia, Professor Mark served on the bipartisan U.S. Commission on International Religious Freedom from 2014 to 2018, serving as chairman in his final year on the commission. He is a fellow of the Witherspoon Institute, an affiliated scholar of the James Wilson Institute, and the American Bible Society's Faith and Leadership Discovery Center. He is a senior fellow of the Religious Freedom Institute's North American Action Team. He holds a BA, MA, and PhD from the Department of Politics at Princeton University. His book, The Nature of Law, Authority, Obligation, and the Common Good, which is the focus of his lecture today, was published by the University of Notre Dame Press in 2024. Please join me in welcoming Professor Danielle Mark.
Thank you very much, Christian. Thank you, everyone, for being here. Tyler already used the joke, but I was going to say, I don't know what it says about Philip Munoz that this is his idea of an April Fool's joke. Also don't know if the joke's on me, the joke's on you, but I guess we'll find out soon enough. In all sincerity, thank you to Philip and the Center for Citizenship and Constitutional Government, everybody there, Tyler Castle, Anna Bradley, Zane Mabry, and everybody who's been involved in making this trip terrific and a really great visit here, even though a short one compared to a wonderful year that I spent here when I was working on the book and doing other things, including having my first kid, who is a native Hoosier as a result of that. I actually the book I do recommend that everybody buys the book. I don't per se recommend everybody reads the book, but the book is the shortest part of the book is the dedication, which is for my sons. And if you would just indulge me as part of that dedication, a quote. There's a reference to this, but the great author Dr. Seuss, in his classic work Horton Hatches the Egg, he writes, "Did he run? He did not. Horton stayed on the nest. He held his head high and he threw out his chest. And he looked at the hunters as much as to say, 'Shoot if you must, but I won't run away. I meant what I said, and I said what I meant. An elephant's faithful 100%. And so in my personal life, I find that to be a very moving passage that encapsulates what I try to express in that dedication to my children. And so thank you for indulging me in sharing that with you today. I also, by way of thanks, want to thank the University of Notre Dame Press, which published the book, and it is really beautiful. So the good thing about when you buy it, you have a piece of artwork on your shelf, or more likely on your coffee table. And also, as I always say, I will inscribe it with absolutely anything you wish if you buy the book. So think of the wildest and or most flattering inscription you can think of, and it's yours. Stephen Rinn, who runs the press, my editor, Megan Levine, they did an absolutely incredible job and were an unbelievable pleasure to work with. And I mentioned that not only express my thanks, but in the hope that all of you will increasingly appreciate, as you may already, what an unbelievable press you have here at Notre Dame. The book. I think we'll do it in 3 parts. The first part, the big part, I'll tell you a little bit about what the book's about. Then I'll say in a briefer section why I think it might matter for scholars, people who are interested in jurisprudence, philosophy of law, and the other fields that were mentioned kindly in the introduction, and then a little bit about why the book might matter for the rest of us, those in the audience maybe who shockingly aren't targeting a career in analytic jurisprudence, and it's like, is there anything in it for you too? So hopefully the answer is yes, even if it's hard to find. So first, what's the book about? So I do like to joke, as I say at the start, that legal philosophers care mainly about 2 kinds of law: traffic laws and Nazi law. Those are, thank you, yeah, I appreciate it. That was with the hope of a laugh. So let's talk about traffic laws and my famous case of the mythical traffic light. So you're driving maybe in some deserted flatlands of the Midwest, and not the kind of roads we have in New Jersey or the Philadelphia area, but you come to a traffic light in the middle of the night, in the middle of nowhere, and it's well lit, there's a clear view in every direction, there's absolutely nobody and nothing around. What do you do at the red light in the middle of the night, in the middle of nowhere? All right, well, show of hands, who's gonna stop? Let's see what kind of audience. This is how I gauge the, all right, okay, know what to expect. All right, I have my eye on the rest of you. Now, in one respect, there's a psychological question, which is like, what would you actually do? Would you stop the light? What are the psychological motivations, perhaps, that determine that, or why wouldn't you? And of course, there's a sociological question, kind of we look at the room as a whole, of, well, what are most people gonna do when they get to that traffic light? But there's also, importantly for me, the philosophical question, or if you want, the moral question or the ethical question. The terminology itself doesn't concern me that much, about what is the right thing to do. See if I can do a better job balancing my papers here and have both hands free. What is the right thing to do? Do you have an obligation to stop at that light? And not just a legal obligation in the narrow, though that might be a question in a certain way, but not just a legal obligation in the sense of like, does the law say to stop? Well, it might not be a simple question, but if it is, the simple answer is yes, it's a red light, you're supposed to stop. But do you have a moral obligation to uphold that legal obligation? Is it just a question of whether you're going to get a ticket, or is it a question of whether it would actually be wrong to go through that red light? And so the reason legal philosophers really do like traffic laws so much is it allows us to come up, in the case of the traffic light, it allows us to come up with a case where there's no reason to obey the law other than the fact that it is the law. No reason to obey the law other than the fact that it is the law. By stipulation, we've ruled out all the other factors, right? There's no danger going through this intersection. There's no one around, and you can see that, right? Not a different case where like there's a lot of hedges at the corner and you can't see, maybe none of that. By stipulation, all the other factors are ruled out. Does the authority of law depend on the reasons behind the law, or just the fact that it is law? Whatever that means. So would we say that in a situation like this, where the reasons behind the law don't apply, the law doesn't apply? Is that what we would say? And as I said, traffic laws are a really good example because there is no inherent moral obligation, whether you're a natural lawyer or a utilitarian or anything else, there's no inherent moral obligation to stop at a red signal in the absence of any law that says stop at a red signal. There's nothing about the red signal per se. And there's even nothing intrinsically necessary about the specifications, right? That intersection, if we wanted to do something about the intersection, and we don't have to, right? We could have, I'm told there are these experiments at dangerous intersections where they take everything out of the intersection and safety goes up because people just realize they have to proceed carefully through the intersection, and somehow that works. But even leaving that aside, right? If we wanted to do something about this intersection, we wouldn't have to put a traffic light. We could try a stop sign or a yield sign or a roundabout or any number of different devices that we could use in order to try to achieve our aims at this intersection. And I want to be clear, this is a little bit of a side point, but important. If you mistake this point, it's a problem. This is not to say that traffic laws are arbitrary or somehow disconnected from morality. They're absolutely rooted in morality, in principles, but the specifics are not rationally required. All right, so what are the principles at stake at the intersection? Well, most obviously, the safe passage of everybody through the intersection. We don't want cars crashing or cars hitting pedestrians, all the things that you would expect. There's also a concern for efficiency, and not like in a bare economic sense, but right, the very important goal of making sure that people can get from A to B in an efficient manner, which has economic consequences in like a strict quantitative sense, but other consequences as well. That's also, and everything we do at the intersection is a trade-off in certain ways, either a trade-off or not a trade-off, but is taking into account these two factors of safety and efficiency. Obviously, we could have maximum safety and no efficiency, like just by shutting down the intersection or something like that. And in some cases, I say not necessarily a trade-off, because we could maybe increase the two together in some situations. But what we know is that the specific decision at that intersection is in the area of what Aquinas would call determinatio, or determination, that we have to make a judgment about the best way, or what Blackstone would call matters of indifference, that not indifferent in the way we use it, like we don't care, but again, there's any one of a number of solutions that we could choose here that would be appropriate to our goals, even though we might still have a good faith disagreement about which one is better, which one is worse, which one strikes the right trade-off, or the right trade-off, like we do with speed limits, right? Speed limits are a similar thing. We're, in that case, really trading off safety and efficiency. We can move faster with less safety, or we can move more safely with less speed, less efficiency. And again, for any given speed limit, it's a judgment call about what the right trade-off is. So again, moral principles that are implicated, but without any rational necessity for any particular solution that we choose. So traffic laws then allow us to test whether the obligation to obey the law applies, even when the reasons behind the law don't apply, precisely because there's no inherent moral obligation stopping at a traffic light in the way we have an inherent moral obligation not to murder, or something simple and straightforward like that. Is there a moral obligation to obey the law just because it is the law? And my answer is yes, probably, or at least probably. A fairly confident yes. But now we have a problem. Our other favorite kind of law, Nazi law. There's the ancient maxim that I'm sure many of you have heard, that an unjust law is no law. Law is related to justice, and law without justice isn't law, perhaps. I'm a professor at Villanova University, an Augustinian Catholic school, as they like to say, and so I fulfill now my contractual obligation by invoking St. Augustine, who said that kingdoms without justice are great robberies. Right, expressing a similar idea. Right? What distinguishes a gang from a government? Well, the justification. Right? In both cases, it's the people with the guns telling you what to do, but we think that one version of that authority is justified and one version of that authority isn't justified. So back to Nazi Germany. Well, it sure looks like there's law. I mean, just kind of, hovering overhead from maybe your drone or something like that, right? I mean, I see the operation of law going on in the way I can see the operation of law going on anywhere else. I see, in some cases, maybe there's legislatures that are making decisions, or officials of one sort or another. There are officials that are implementing those decisions. There are people who are regularizing their behavior around the specifications of those decisions, and so on. And the Nazi law example is, always the go-to example, because probably among us, the Nazis are uncontroversially unjust, right? We don't have a lot of disagreement about whether we consider the Nazi regime to be just or unjust. And yet at the same time, it sure looks like there's law. And this is why positivists, this is not where positivism starts, but this is positivists, example bar none, that we can identify law without respect to normative criteria, without asking about the morality of the law. And what's the proof? The proof is that, like, anybody flying overhead slowly over Nazi Germany can see the operation of a legal system. And the justice or injustice of the laws just isn't relevant to the question of whether there are laws there, whether there is a legal system. So again, the idea that it is wrong to define law by its relationship to morality. Instead, we can use non-moral criteria to define law. So what makes law law? Well, the older positivists had different theories, but in some ways similar theories, in some cases centered around the idea of punishment. So the sanctions are what makes the law law. If there's a rule you have to follow and you get punished for not following that rule, that's the law. Habits of obedience, the idea that the sovereign is the one who has habitually obeyed and who habitually obeys no one else. These are how the older positivists think about sovereignty. For Hart, who we'll say more about, HLA Hart, Herbert Hart, one of the towering figures of jurisprudence in the latter half of the 20th century. For Hart, he didn't like sanctions-based theories. He didn't like habits of obedience. He liked the idea that laws were rules based in social practice. That we can identify law without respect to normative criteria, without questions of morality or justice, as long as we can see that the law meets with the criteria for law in that society, whatever they are. So maybe in our case with federal laws, the law has to be passed by a majority of both houses of Congress and signed by president. And we can identify that law as a law without any questions about the content of the law, whether it's just or unjust. What Hart calls rules, we use rules of recognition, right? It could also be just like the king announces it and posts it to the telephone pole outside the palace or whatever, right? And that's the law, whatever it is. But those are, right, they're all non-moral criteria for identifying the law, as is the case with theories based in punishment, right? It could be a good law or bad law, but if you're gonna get punished for not doing it, that's the law. The sovereign might be a good sovereign or bad sovereign, using those terms in the ordinary way, but if it's the one who has habitually obeyed, who habitually obeys no one, that's the law. Which brings us back to traffic laws again, and asking why Hart rejected the old positivist way of thinking about law. So Hart says, this is not where he gets it, but again, looking at Nazi law, he says, well, we've got this idea that we have to define law in non-moral criteria, because if not, we're just denying what's in front of our face. So you could just say, oh, the Nazi Germany didn't have laws. But anyone's like, no, I walked around Nazi Germany. I'm pretty sure they had laws, right? There were stop signs and traffic signals and taxes and environmental regulations, and which, who knows, but whatever it is that they had. So here's Hart's main point about why he doesn't like the old positivist way of thinking about things, punishments, sanctions, habits of obedience, and wants the new way, rules based in social practice. And the reason is that he says people don't relate to the law the way they relate to a mugger. So a mugger puts a gun to your head and says, give me your wallet. So Hart says in that situation, You're obliged to give the mugger your wallet, but you're not obligated. Meaning what? Right? If you got away somehow, right? If you did not turn over your wallet and you managed to create a diversion and escape, no one would say, oh, you did something wrong, right? You somehow failed to fulfill an obligation you had to give your wallet to the mugger. But people don't relate to the law that way. He says people don't simply relate if you look from what he calls the internal point of view. If you look from the internal point of view, people don't relate to the law, they relate to the way they relate to a mugger. I mean, yes, some of us obey some of the laws some of the time because of the fear of punishment, but largely people obey the law with a sense that they have an obligation to obey that law, and that they'd be doing something wrong if they didn't follow the law, just like you might point to them and say, you did something wrong, in the way you wouldn't when they got away with their wallet from the mugger. So the distinction between being obliged and being obligated. He says with the traffic light, he says that it's wrong to look at it just from the external point of view. From the external point of view, the traffic light is just a sign that people will stop. So hop on your drone again, fly up over the intersection, and what you're seeing is signal turning red and cars approaching the red signal stopping. Signal turns green, the other cars go back and forth. And all you know is that the traffic light is for you essentially a prediction of people's behavior. It's a prediction that people will, right? The red light predicts that people will stop and the green light predicts that people will go. And Hart says that's fine from the external point of view, but from the internal point of view, there's much more going on because the people driving the cars don't just look at the traffic signal as a sign that other cars are going to stop, but as a signal for stopping. It's an instruction to them to stop and an instruction that they have a reason to follow. Not just an expectation of what will happen, but a standard against which they can measure their behavior as either right behavior or wrong behavior. So where do I come in? Well, my claim, one of my central claims on the negative side of the book, not in constructing my own theory of law, but in first telling you why the other guys are wrong, I claim that Hart's theory doesn't work because he can't account for the obligation, for the sense of obligation that is now at the center of his theory. It's the two parts of Hart that I just told you. The first part about Hart was that he wants to be a positivist. He wants to say, hey, take a look at how far can I walk without making you move the camera? Is this, do I have some latitude here? Do I have some latitude in moving around without that? Yeah, okay. Yeah, so I know this is on camera, just like wander right out of the frame, or like maybe do like Marco Rubio with the water, I don't know. The two parts of Hart that I just told you about. So the first part is that Hart wants to be a positivist. Hart wants to say that we will define law without respect to normative criteria, without asking questions of morality and justice. So law is now separate from morality in that respect. Doesn't mean that law can't touch on morality, but morality, the justice of the thing, is not what makes law law. Okay, he's a positivist. He's probably wrong, but you're allowed to be a positivist. There's all types in the world. But now we have this other thing, that Hart's great innovation in legal theory, revolutionizing, his book is called The Concept of Law, revolutionizing the concept of law. Hart revolutionizes the concept of law by telling us he's still a positivist, but all the old positivists were wrong. Everybody up till now was describing law as a command, as I actually like to do, as an order, and that's wrong because from the internal point, what that misses is the crucial internal point of view, which is that people relate to law with a sense of obligation, not the way they relate to a command from someone with a gun to their head, not the way they relate to a mugger. And my claim is that those two parts just can't go together. You can't argue on one hand that what distinguishes law as law is its sense of obligation, and that the definition of law is completely divorced from morality, because then where does the obligation come from? It's only the moral aspect of law, the justice of the law, that can give us the obligation. I mean, there is this other alternative, and the alternative is mass delusion, right? That everybody has a sense of obligation to the law, but nobody actually has an obligation to the law. But that's not a real, I mean, if that's what Hart's theory rests on, then I think he's in pretty bad shape. As we discussed with some of the students earlier today, this is a pretty bold claim. Even people who reject positivism still take on board a lot of what Hart is saying. Like nobody, even the natural lawyers, don't agree with me that we should ditch Hart's idea of law as rules based on social practice and should go back to commands. But I really like the idea of command, and very much for this reason, because a command, now commands might obligate or might not obligate. I might just command you right now, and you might say, like, buzz off, right? Like there's no reason that this nice fellow has to do anything that I say, right? But when I give a command, you understand that I intend to obligate you, and obviously I understand that I intend to obligate you. And so as a placeholder, as a category, as a description, we still need the evaluative part, the normative part. But as a description, I think command actually fits much better. Now, there's other questions we can ask. Somebody in Q&A wants to get into common law. I don't settle everything here, and I may create more problems than I create. I may create more problems than I solve, but I'm sticking to it. And I think that I have identified a problem in Hart that's bigger than people want to acknowledge up until now. And that is a problem because so much of the jurisprudence after Hart is built on Hart. And so in the book, I mentioned a few other people writing today who I think have very interesting and elaborate theories that ultimately fall apart because of the foundation that's at the flaw. Although I don't need you to entirely to take my word for it. Usually we consider an appeal to authority a logical fallacy, but in this case, it may be authority great enough that we can all agree, and that's back to the great man of letters, Dr. Seuss. This will be my second and final quotation from Dr. Seuss today, and I am genuinely not making this up. So Hart wrote The Concept of Law in, I think it was like 1961 it was published, give or take, and the great Dr. Seuss took about a dozen years to digest it, and then I'm not making anything up, in Did I Ever Tell You How Lucky You Are, which is a totally underappreciated work of Dr. Seuss, by the way, he says as follows. And remember The Concept of Law by Herbert Hart. Suppose, just suppose, you were poor Herbie Hart, who has taken his thromdimbulator apart. He will never get it together, I'm sure. He will never know if the gick or the gore fits into the scrux or the snux or the snore. Yes, duckier, luckier, not Herbie Hart, who has taken his thromdimbulator apart, right? So what it took me 400 blessed pages to do with Notre Dame Press, Dr. Seuss did in a short paragraph, right, expressing this central insight, right, that poor Herbie Hart has taken his thromdimbulator apart and it is not getting back together. He has deconstructed the concept of law in the name of his new positivist innovation, and now having introduced the new ingredients, as you will to mix metaphors, I guess here, having introduced the new ingredients, he simply cannot get the thing back together again. It is for whatever doubts I have about any claims I make in the book, right, the one that I'm sticking to is that these two central parts of Hart's thesis cannot go together. They are irreconcilable with one another, and they leave his work fatally flawed. Incidentally, it's not that the entire book is about Hart. There's a lot of pages about Hart, but not the whole thing. And so I just wanted to talk about two implications of Hart's positivism and why, in his inability to put the thromdimbulator back together, I think he has more problems than he realizes. So again, the book gets a lot of analytic jurisprudence, but one of the examples that Hart talks about is the post-war German trials, right? War crimes trials for people on the German side who participated in war crimes. And Hart says, well, these trials present a problem, right? There's an interesting moral quandary here. We're putting people on trial for things that were legal when they did them. And isn't that a puzzle? Well, yes, sort of. But here's the problem. It's not as big of a puzzle as Hart, I think. It's not as big of a puzzle as Hart thinks. Because for Hart, law is completely divorced from morality. And if that's the case, the fact that these people did what was legal at the time they did it, or even had a legal obligation to do it, tells us really nothing about their moral obligations. And so it's a little bit of a puzzle, but I don't think it's a great puzzle, because what we're saying is that on one hand, they had a moral obligation not to commit the war crimes, and on the other hand, they had a legal obligation that carries with it ostensibly no moral obligation. So what they did was wrong, and there's not a lot of conflict in the fact that what they did was wrong. It's still a puzzle, but it's a little puzzle. I think if you take my view, it's a bigger puzzle. If there is a moral obligation, we haven't obviously gotten into this yet, but if there is a moral obligation to obey the law just because it is the law, now we've got a real moral conflict. Now, on one hand, the person perpetrating the war crime has a moral obligation to do it, has a moral obligation to follow the law just because it is the law, and then a competing moral obligation not to do the thing that is being instructed by the law. That's a real quandary. That's a real conflict. That's a real conundrum. Now, it might be the case that we think that we know which of the two competing moral obligations is stronger. So maybe the moral obligation not to kill the Jews is stronger than the moral obligation to follow the law in this situation. That might even be an easy case for us. But the puzzle is a much better puzzle if we think that there's moral obligation on both sides of the equation, in a way that I think the puzzle really doesn't get off the ground in a meaningful way if on one side there's moral obligation, on the other side there's legal obligation attached to no moral obligation at all. So I think that embracing Hart's theory obscures for us what's really interesting about a puzzle like that, what really makes it a problem. I think similarly, if we take Hart's side instead of my side, if we go with the positivists, we might lose something that's important in the idea of civil disobedience. So one of the standard features of civil disobedience, not that it has to be the same in every case, is that someone breaks the law but also accepts the consequence, right? Part of engaging in civil disobedience is not going on the lam as a fugitive and trying to evade justice. It's more like, I'll break the law and then you can arrest me. Now, there might be a bunch of reasons for that, but I think the central thing that makes sense of this is the idea that in engaging in civil disobedience, one is, in a certain sense, both doing something right and doing something wrong. If there is a moral obligation to obey the law, then there is something wrong in breaking the law. Now, that wrong in breaking the law might be eclipsed by the wrong of the injustice that one is protesting through civil disobedience, right? It might be more wrong to do what the law requires. It might be more wrong to return the fugitive slave or something like that. But it also might be a little bit wrong to break the law if it's the case that there's a moral obligation to obey the law just because it is the law. And I think if we take my side, we can make sense of that. I think if we take Hart's side, it's much more difficult to make sense of that. And so, having said all that, in the book, what I want to do is two things. One, as I mentioned, I want to go back to the older way of thinking about law as command instead of thinking about law as rules based in social practice. And I write extensively, in addition to what I've said, about why I think that's problematic. And I also want to join everyone who rejects positivism in saying that the definition of law must be connected to justice. There must be a normative component. There must be a moral aspect to a moral criterion somewhere in our definition of law. And for that reason, I end up defining law as a set of commands oriented to the common good. A set of commands oriented to the common good. And in that respect, I don't think I'm improving much on Aquinas' definition of law. So plot twist, someone said this 1,000 years ago. An ordinance of reason for the common good made by him who has care of the community and promulgated. And so there's also more to go into there, but we're not doing everything today. And what you should notice there, then just to wrap up what I'm saying in the book, and hopefully leaving you with the appetite to discover more, is that in describing law as a set of commands, as I've already said, I'm thinking of command as a good description, therefore command as the central case of law, like the paradigmatic example of law is a command from the sovereign or the legislature or whatever the arrangement is. And also, as a set of commands, I'm thinking of the legal system as a whole. I think that the moral obligation to obey the law inheres in the legal system as a whole, and from there to the individual laws, but again, not because of the content of the individual laws, but because of the orientation of the legal system as a whole to the second part, which is the common good. And law is unavoidably normative, and it is the normative aspect of the law that gives it its justification, gives it its moral force, and that is to be judged by the orientation, as I just said, of the legal system as a whole, which is how you can get into a situation where there could be, like I said in the case of civil disobedience or Nazi law, there could be a low-level moral obligation to obey the law just because it is the law, even if it's a bad law, as long as it's part of a good legal system, and which opens another can of worms, but I'll leave that there for now. Okay, briefly, and it's till 1:45, right? Is that the, okay. I like leaving lots of time for discussion, so I hope we'll do that. I hope I will do that, and then I hope we'll have a good discussion. Well, for one thing, so why does the book matter for scholars? Well, one of the things that I've tried to allude to all along the way here is that positivism is really dominant in analytic jurisprudence, in philosophy of law. Hart and Raz, who I haven't spoken about today, but who thinks that the law applies only when the reasons behind the law apply, are extremely influential. Almost everything that is written today builds off of what they wrote. And I think, as I said, that a lot of the scholarship has problems because they're inheriting the flaws from Hart and Raz. And as I also said, I think even non-positivists, even people who reject them, take a lot of their theory on board that can also lead to some mistakes because they're sharing some of their framework, some of their premises. Another topic, again, that may be interesting to people more who want to get more into the weeds, is that I am arguing, because I say that law's authority comes from its orientation to the common good, that authority, strictly speaking, does not require consent. Now, that might seem troubling, worrying, un-American even. I answer, as Aquinas would say, well, actually, we have lots of moral obligations that come to us without our consent. And anyway, consent theories don't work. So, so in the absence, so maybe it's the worst theory except all the others. But there it is. Something that's not in the book, but again, just a little bit of red meat for people who hopefully this will upset maybe one person in the room, is in philosophy of law, there's a lot of talk, in part thanks to Joseph Raz, again, about first order and second order reasons. The idea being that a first order reason is a reason to do something or not to do something. A second order reason is a reason to act or refrain from doing something based on a reason. So it's kind of like I've got, imagine the naked intersection. I've got reasons to stop, reasons to go. I'm in a hurry. There's safety concerns, kind of all the basic do's and don'ts. And then the law comes in as a second order reason, which means it instructs me to refrain from thinking about or acting on the first order reason. So it kind of like displaces the first order reasons and comes in and says, don't do the calculations. And everyone accepts that, and I'm skeptical that it's actually right. If the way I'm talking about the weighing of a obligation to obey the law against competing moral obligations, the way I think civil disobedience works, right? On one hand, I've got an obligation to obey the law. On the other hand, I've got an obligation not to return a fugitive slave or not to kill the Jews or whatever the case may be. I think really does constitute just a weighing of first order reasons against first order reasons. And I think the second order reasons thing is a fascinating device that actually kind of collapses when you push on it. So there's something to think about if you're actually here because you care about philosophy of law. For the rest of us, again, I'm not a scholar. I just play one on TV. One of the important takeaways from the book is the focus on the importance of the common good for our political and legal regime in our extremely polarized times. To pick up a cliche, I think that the more we can be reminded, and the more that we can remind ourselves that the best version of democratic politics is contestation over competing visions for the common good, the better off we will be. Now, there's a problem here, which is that many people might believe, perhaps correctly, that the other side really does want to destroy the country or something like that, right? Like if that's your belief, then saying that well, actually we're just arguing about competing visions of the common good might seem naive, might seem even dangerously naive. And yet, at the very least, as we get into the knife fight, the more we can remind the knife fight, that is our contemporary politics, as we get into the knife fight, the more we can remind ourselves that the thing that we're actually trying to get to, I think this is what Abraham Lincoln would have wanted, the more we can remind ourselves that the thing that we're actually trying to get to is the common good and not the destruction of one faction by another faction, maybe the better off we'll be in the long run. Maybe that's our chance for achieving a just and lasting peace. Again, I don't say that lightly. I don't say that with wishing on anybody any naivete that allows the other side to destroy them, although perhaps better to suffer injustice than to commit it. But I say it nonetheless. Returning to the great line from Augustine, which is closely related, kingdoms without justice are great robberies. Thinking about in this day or any day, and I want to be super clear that this is not a partisan comment about the current administration, actually something I wrote and thought about before the current administration, which is not to say it's about the last administration either. This is an equal opportunity point for anyone who wants to get upset, is thinking about at what point a state becomes a tyranny, right? So if my argument is that the justification of law is the orientation of the legal system to the common good, well, then that means by hypothesis that there's going to be a legal system that is no longer. There's going to be a situation. Somebody this morning asked me, "What do you think about the American Revolution? Justified or unjustified?" So maybe it's just water under the bridge anyway at this point. But this idea does necessarily point to the position that we could reach a conclusion that a legal system isn't oriented to the common good, in which case it is no longer justified, in which case it is something like a tyranny. And this is certainly, rightly or wrongly, this is certainly a question that's come up even in contemporary politics over the past number of years. It's part of the language of our politics these decades. The question of another question worth thinking about, again, going back to the founding and the Declaration of Independence, the importance in the Declaration of Independence of consent of the governed, and then here's this weird guy from a this is being broadcast. I'm gonna leave out the joke. Here's this guy saying that actually authority can be justified without consent, right? We actually we could live under a king or a queen, and that would be something that in theory could be justified as long as the laws are oriented to the common good. And this deeply held American belief that justification of authority depends on the consent of the governed. Maybe that's wrong. In trying to describe the shape of legal obligation in the book, I compare it to moral obligation and religious obligation. And the reason I give them these cute names, I talk about moral obligation as reasons without commands, right? So from the natural law perspective, but really from any ethical perspective, we have moral obligations that don't come from a command of any sovereign. In the sense of we're leaving God out of the picture for a second here, right? It's wrong to murder or enslave or assault in other ways just because it is wrong and not because someone told us it's wrong. And happens to be that's what you would think about your ethical obligations if you're a natural lawyer. It's also what you think about your ethical obligations instead if you're a Kantian or a utilitarian or any other popular ism. And so moral obligation is one kind of interesting case where we would have reasons without commands, right? There's reasons why these things are wrong, and they're wrong for us to do, even without anybody commanding us to do it. Religious obligation, I say, is kind of the reverse, potentially, commands without reasons. So if God commands me to put a yarmulke on my head, which he didn't, it's just a custom, but if God commands me to put a yarmulke on my head, I put a yarmulke on my head. Is there a reason? I don't know. Does the reason matter? I don't know. What if the reason doesn't apply? It doesn't matter. It's a command. I'm mindful of the fact that that is not often the way we often think of our religious obligations, but I think it's a possible model of religious obligation, is commands without reasons as the opposite of reasons without commands. And I do think, sort of in closing here, that's an interesting point to connect to how this fits with Catholic thought about faith and reason and the goodness of God, right? So those of you who are still listening, and the last thing I said, right? Well, commands without reasons actually doesn't sound like a comfortable way to describe, if I may, the Catholic way of thinking about God and his commands, because God commands what is good in his goodness. But I think I have a point here, which will or won't be accepted by the Catholic mind, but thinking about the possibility of goodness, of obedience to God just for its own sake. That the nature of the relationship with God is such that obeying God for no reason would be fitting for that relationship and good for us. That it may even be a gift from God to have to do some things when we don't understand it. And the only, what's the right way to say this? The one thing, and the one thing that we have, that one thing that we can do when we don't have a reason is obey. When we have a reason, we might be obeying, but we also have a reason for doing it. When we have no reason, the one thing we can do that we can't do when we have a reason is obey just to obey. There are, weirdly, some people I know who have opened the book, and one of my former students who now flies helicopters for the Navy, he's an evangelical, which good enough for now. He sent me the following message, which I thought was really fun and flattering to receive. He wrote, "From what I've read so far, I found it incredibly thought-provoking for my faith and for parenting of all things. Specifically for one of those thoughts, how do I teach Levi," that's his son, "how do I teach Levi that he is a being under authority without subverting that very authority? He is under my authority, yes, but ultimately that is granted by God, as is the state's authority." So this is retweet does not equal endorsement. "So I need him to begin to grasp that concept even at a young age. I've tended to hold him to my word and then explain. I've tended to hold him to my word and then explain. Don't touch the stove because you might get hurt. But I'm wondering if that is teaching him to obey authority as an advisor and not out of any obligatoriness, his word, thus stripping the authority of the hold that it rightly has. I'm wondering if the because I said so is better as an impulse, but then also adding in the and also so you don't burn yourself to build street cred. Or with my faith, I've been pondering whether the nature of obeying the Lord's commandments when I understand why they are there versus when I have no idea why the heck I need to do that thing. Sorry for the French. It's a matter of authority and obligation, not necessarily a matter of understanding and knowledge, although the Lord is often kind to grant the latter two when asked." So maybe on a good day, if I'm lucky, though it's not what I'm writing about directly in the book, I hope that thinking about authority and obligation in the way that I'm proposing maybe can also give us insights into the idea of obedience. And even though I think intuitively the Catholic approach doesn't see religious obligation as commands without reasons, maybe there's like one corner of divine command that's worth thinking about that, because again, as I said, it gives us the one thing we can't get otherwise, which is the opportunity to obey, which is to say not to do things because we have reasons and understand the reasons and like the reasons and the reasons apply, but just because it's good to obey, which probably would be true for God, but maybe not in the same way for the government. Okay, you've been very kind, thank you, and let me please take any comments or questions you have.
Hi,
Hi.
First of all, thank you very much
Thank
for
you.
that amazing presentation. My name is Angel Muñoz, I'm a lawyer from Honduras. I'm currently a JSD student at the law school. I'm just wondering what would your conception of the relationship between obligations and rights is? How do you understand that, either duality or separate binomium?
Yeah. Right when Tyler said at the beginning, it's like, oh, look at the subtitle. All you need is the word. I was like, no, rights aren't a thing. I'm just totally kidding. I think, and this is actually something I think either I want to write about more soon or somebody else should. I'm definitely persuaded by whatever you want to call it, the natural law case for rights or the conservative case for rights or whatever. We'll figure out as we write about it what the right label is. Rights. So yes. So it's very. Whenever we talk about rights, we're supposed to say, well, we need to think about rights in the context of duties and like that. So rights don't come without duties and all of that. Yes. Blah blah blah. There's actually this. There's a old from a while back, deceased, died young, unfortunately, Yale law professor named Robert Cover, who was like, that's actually the Jewish idea. Like the Jewish tradition doesn't talk about rights, it talks about duties, and that's better and whatever. The way I want to talk about it is the way some in the natural law tradition have been talking about it now for some time, is that we have to understand rights in terms of goods. And that the appropriate and most solid ground for rights is in the goods that they protect. The reason rights are important, the reason rights matter, is because of the basic human goods that we can participate in when we have the rights that allow us to do so. So the goods of friendship, the good of friendship, the pursuit of knowledge or truth, that is not possible without free speech. And in another way, actually, with privacy. I was earlier recommending today Robert George's first book from 30 some odd years ago, Making Men Moral, subtitle Civil Liberties and Public Morality. Right, the last chapter of that book is one of the earlier recent writings making this case. I think that our rights are best understood in terms of the goods they protect, and that's actually the surest philosophical foundation for them. So that is right, freedom of religion. Freedom of religion is valuable because it protects our ability to participate in the good of religion. The rights aren't for their own sake, but they are for the goods that they protect. And this gives us lots of downstream implications. Like one of the things he writes, which doesn't maybe sound like some of the things that people are writing today, is that by the same token, valueless speech has no inherent right to be protected, right? It's definitely not a libertarian approach. Valueless conduct isn't protected by rights, which is part of his larger argument in the book, that there's no such thing as a right to do a wrong, and autonomy is not a basic good, and so on. But anyway, so I'll leave that there for now, and then see if I'll have more to say if no one else has anything else. That's my threat. I'll talk about that more. Yeah.
Afternoon, I'm Kevin Bisley, a freshman studying history and Con Studies minor. So getting this idea of law as a command, I guess it seems to me that there's sort of an implication that this command needs to come from some sort of competent authority figure. So I was just wondering if you could speak a little bit more on that. Sort of what do you think characterizes the sort of authority figure that would be competent to do that? Because, I mean, I, for example, could give some sort of command to every person in this room, and there would be no moral reason anyone would be obliged to follow that. Or the mugger example is another.
Yes, exactly right. Exactly right. So by virtue of you merely commanding, that's not a thing. And that's why, like, as Aquinas says, right, it has to be the duly constituted authority. Now, what that also means is that if someone's in the office, meaning the office of the duly constituted authority, that person doesn't necessarily have to have any other qualities other than being the one in the office. Now, if the commands, the promulgations are not for the common good, we end up with a different problem, but it's not the problem of is that person the authority figure or not the authority figure. Now, of course, what this Leon Finnis writes about this, Finnis writes about this because Anscombe writes about this, that you are going to get a recursive problem here, which is, well, where does that authority, how do you get to make the duly, where does the authority of the instrument that determines what is the duly constituted authority? And so the way Finnis talks about it in terms of like the first unauthorized authority, right? Like, I mean, ideally there's some kind of unanimous selection of an authority figure at the start. This is kind of like the idea behind like the ratification of the US Constitution, that everybody has to participate in and it has to be, it's not unanimous, of course, but like a higher threshold for getting everybody on board. All the states have to be in, kind of thing. But I think that in the end, there's not going to be I don't say there's going to be a good answer. There isn't going to be a neat answer to the problem of the first unauthorized authority, which is why, so for those, if you're actually interested in this, in addition to reading what Finnis says, so Anscombe's article, Elizabeth Anscombe's article on the source of the authority of the state, which is a pretty famous piece by her. She has this kind of like, she calls it like, it's maybe like her expression is like 2 bites of the cherry, I think, like 2 bites of the apple, 2 bites of the cherry, where we kind of have to do both moves at once, where it's basically authorized by, it's authorized because it's necessary. And you say, well, wouldn't that justify? So it's a tricky kind of move, but I think that's basically right, that at some point it has to just spring into being by virtue of its necessity, and then meet the normative criteria for what's necessary, but for meaning like the common good moral criteria. But yeah, but it's I think it's an unfortunate question that doesn't have a neat answer, like, and probably can't, because unless you just pick a different theory that says, well, we just all vote and that's the person, but even then, really every theory is going to have the recursive problem, because well, where do we get the idea that we're all going to decide by a vote? Well, did we take a vote on that? Well, where did the authorization for that come? Oh, from taking a vote on that. Well, where, and then it's just turtles all the way down. Yeah, thanks.
Thanks, Danielle. That was great. 3 thoughts, maybe 4. I'll try to be quick.
Okay, I'm ready.
One, just the thought that the notion of law as command. So I know in my thinking, my thinking's been influenced a lot by Philip Rieff, where Philip Rieff talks about sacred order. And he doesn't talk about it in terms of command so much as he talks about it in terms of prohibitions, right? So he says, when we say there is nothing sacred, really what we're saying is there's nothing that can't be done, right? So that there are, so that a mark of the sacred is a set of prohibitions. So I don't know whether that, thinking about that, if you thought about a distinction between commands and prohibitions. So that's one question.
Okay.
So second has to do with this potential conflict between reasons without commands and commands without reason. That you described, and my sense is that, at least in Aquinas' thought, and that when he characterizes law, he starts out with the first 2 articles of it. A law is an ordinance of reason for the common good, and that whether it's a command or whether it's a reason, I think the presumption is that it's for the common good. Right, and so I'm not sure that. So when he talks about divine law, and when he talks about natural law, I think it still fits this structure. They're both implicitly, and I guess that can be argued. They're both implicitly from God. One is explicitly from God, right, and the other is implicitly from God. But they both have the character of a reasoned, legal injunction, a reasoned authority for the common good, whether it's given as a command or whether it's deduced. And then the third thing is that if that's true, it seems to me there's a certain sense in which prudential judgment comes into at least the natural law issue, if not also thinking about response to a divine law that may not be, if there's a difference between command and a command and a prohibition, I'm not sure about that. But I'm just thinking, though, that there's the prudential judgment aspect, it seems to me, is baked in for the way that we respond to law. And I mean, part of that response, because I want to go back to I think the final thing is that I was the guy at the stop light. And so I think that part of, and Aquinas says this, that part of a reasoned response to law is sort of giving the law, recognizing that law has an inherent authority, a presumption of authority that's for the common good. Anyway, in my case, in another life, I was driving a taxi in the north suburbs of Chicago, and at 2 a.m, I was at a stoplight across from a railroad track, and there was a freight train that was...
don't go. Yeah.
No. But no, the question was not go straight ahead. Was do I turn and try to go left and go in the other direction and go around it? And I sat there for about 5 minutes, and I won't tell you what happened unless you ask. So.
Okay. Thanks. Thank you so much, and thank you for being here. So on the first point, law is command. First, I actually wait, what was your name? Was Kevin or something?
Oh, yes.
Was it Kevin? Right. So actually, where I thought Kevin was going originally, which reminded me, is that the real question to ask is, if I think about law of command, where does that leave the common law? I think I alluded to earlier. So that was right. But you said prohibitions. So I think commands could be prohibitions or whatever the opposite is, requirements, right? So and a lot of commands are prohibitions, but pay your taxes, maybe is not is not right. It's not a prohibition. Although it does point to, so I would say prohibitions are very important in maybe the majority, but not everything. And I would also say that your question points to, one of the other things that I don't like about Hart that everybody else likes is Hart says there's two kinds of law. There's duty-imposing laws and power-conferring laws. This would also be fun to talk about at some point. But so a law like don't speed or don't kill someone is a duty-imposing law. But other laws are like, if you want a driver's license, here's how you get a driver's license, right? There's no, you want a marriage license, here's how you get a marriage. There's no duty involved there. And I actually think that power-conferring rules, nobody agrees with me, that power-conferring rules are a species of duty-imposing rules. And so maybe thinking more about how Reef's way of thinking about things maybe will give me further insight into this. With commands without reasons without commands. So if I understood you correctly, you said it still presumes the common good. What I'm suggesting, so yes, there's a certain level in which if it is a command of God, then we're just going to assume it's good. But at least I'm trying to create this construct in which we don't know the reason, we might never know the reason, we can't understand its goodness, which is what we think anyway about lots of God's actions, but not necessarily his commandments. And it actually doesn't matter, and I should do it anyway. Now, it's true that we do this in faith that it is good and for the good, but it might also be true that it is a different kind of act in the absence of any reason. In the absence of any reason, and that's why it is an act of obedience in a way that the other acts aren't completely, right? The acts I do with knowledge and understanding of their goodness are, in the loose sense, acts of obedience because God told me to do it and I'm doing it, but also I have good reason to do it anyway now that I see the goodness in it. For acts in which I don't see the goodness or can't see the goodness, and I can only know that God commanded me and that God is good, I think there is an element of obedience to that the other acts lack, which may itself, as I say, be a gift from God, the opportunity to obey without any reason. And as a Jewish person, I do that way more than you guys do, right? Oh no, I can't have a cheeseburger. Why? God said so, right? And this is great. Because you can have cheeseburgers and I can't, so joke's on you. I get to obey. Yeah, and 3 and 4 we'll just have to talk about. I mean, yes, prudential judgment is everywhere. I agree with that. I didn't catch the exact sense of the question, but we'll pick it up later. Yeah. Yeah. Oh, sorry. I don't know who's calling on people. Yeah. But I think they want you to wait for a microphone first. I'll hear you, but the recording might not. Yeah.
Sounds good.
Yeah. And I'll try to get everyone in. As you can already tell, I talk way too much, but also I purposely arrange my schedule so that I don't have to bolt when you get dismissed at 1:45. So if anybody wants to come up, I would welcome that. Yes.
I'm a senior mechanical engineer, so I apologize if the question isn't as deep or philosophical as other questions have been.
Yeah.
How do you
Did they name
conduct?
you?
Excuse me?
Did they name you?
Oh, they did not.
Okay.
I'm
go on.
Aiden O'Brien.
Okay.
How do you conduct research on this topic in order to inform your thoughts?
Yes. Philosophy is the fancy word for thinking. So you have to read and think. That's what I do for a living. And I mean, I teach too. And talking to other people is also really, as Socrates taught us, talking to other people is a really good way for moving your thinking along and for understanding what you're reading. But yeah, so when I say I do research, I mean I'm reading stuff and thinking about it. Yeah. Is that responsive to what you were really asking? Is there, I mean, I don't mean to give your question short shrift. There also are real philosophers in the room. So if somebody, in case I'm missing something, there are people in the room who can tell you, who can tell you better than I can. But yeah. That's what I mean. Like, I know people like, oh, like what? Oh, you do political theory. What's that? I was like, well, look, I mean, the engineers have like real world accountability. Like the bridge could stand or fall, right? And like that's a real. And then you got like mathematicians and like there's like numbers, right? And like the equation might either like the two sides of the equation might be equal or not equal, and like we can check, right? And even historians like ostensibly like there are facts, right? But the political theorists, we're just like straight making stuff up, right? Like just like that's really it. So yeah, maybe we should edit that out before that goes back to Villanova. But yeah, someone just paid me to make stuff up, and then someone publishes it too. So yeah. Oh, subtly your question was, I'm doing real work, aren't you just making stuff up? That's what you were saying, right? Yeah. No, I get that. Yeah. Yeah, no, I think it's the case that the more, I probably don't, the truth is, in all sincerity, I probably don't, I think the more you talk about it, the better. And then sometimes you're just in a rush to publish and you talk about it less, but not because you rushed me. I mean, yeah.
I appreciate it.
Yeah. And I see you also. I'll make sure I get to answer your question too. Yeah. You had a hand, right? Yeah.
My name's John Luke. I'm a grad student in constitutional studies here. Thank you for the presentation.
Awesome. Yeah.
My question is about your theory of civil disobedience.
Yeah.
Because it seems to me that it creates a strange moral quandary where you have conflicting moral obligations.
Yeah.
And you solve that by like doing some sort of balancing. But
Yeah.
I wonder why you don't just hold on to the idea that an unjust law is no law at all, and that the legal obligation drops out in that case, and that you're left with maybe a prudential reason to continue to follow the law. But why do you want to hold on to like the moral obligation in the case of what we think of as unjust laws?
Right. So you're saying in the case of the traffic light where are you saying in the case of the traffic light where the reasons behind the law don't apply, because it's not an unjust law, I can still say that there's a moral obligation to obey the law just because it's the law. But in the case of an unjust law, not like the traffic light, that would just evacuate it of its moral obligatoriness.
Right.
I think, because I don't think I can coherently separate those, right? So if the thing that gives you a moral obligation to obey the law is that it's a part of a legal system that is overall oriented to the common good, then that's going to apply to all of its parts. And I'm saying that the content of the law doesn't matter for that judgment, and so therefore to say, well, when the content of the law is unjust, now I have to disconnect it from the legal system. I don't think I can justify that without just going back to the point that I don't want to make, but which might be right, which is that there is no obligation at the traffic light. Right? If that's the case, then we say no. It matters of the reasons in each. I'm going to evaluate. just for the purposes of is there a prima facie obligation to a moral obligation to obey the law just because it is the law, that depends on the content of the law itself. And if it's unjust, there isn't. If the laws don't apply, if the reasons don't apply, there isn't. And if the reasons do apply and it's just, there is. But otherwise, I don't think I can separate the others.
Do you think there are any cases of individual laws that are part of a broader, maybe just legal system that would lose their moral obligation because they're so contrary to justice?
So for the time being, until part two, I think I'm committed to saying no right now. To your question, although I have a sneaking suspicion that you have an example in mind that I'm not going to like, but somebody else wants to ask a question. So it's like maybe you got me. I don't know, but I'll be excited to hear after. Yeah. Although I don't know, like I already like threw in the Nazis and slavery, so I don't know what you're gonna have that's worse for me. But yeah. Yes or no? Sorry, did you have a hand next to him?
I did. But I thought there was another one over there.
Well, I'll get you both. Yeah.
Okay.
I mean, unless yeah, I don't know. I'm actually not in charge. Yeah.
Yes. My name's Luke. I graduated undergrad here last year, incoming law and graduate student next year. Currently work for the center that's hosting you, but I wasn't important enough to organize part of
the CCCG. Yeah.
3CG.
Yeah, I've heard that before. Yeah. Go ahead.
This may just be a restatement of the Catholic objection that you kind of anticipated at the end.
Yeah.
But you want to carve out the space for the idea of a command without reason or reason without commands as being two different avenues. And you say even in the Catholic conception, like there has to be space for that. And I'm not by any means denying the conceptual viability of that distinction, but with the Catholic claim about God, like the idea of a word became flesh, like the idea that it does not carry with it a presumption not just of the goodness of God's commands, but also not a presumption of rationality, but further than that, like the rationality of God's commands being part of the very article of faith, and makes it almost that distinction impossible for Catholics. And maybe that's just an anticipation of the objection.
No, so the answer might be yes. The answer might be yes. You're right. Because I didn't mean to say that there has to be space in the Catholic understanding for that. I was trying to show why there, even from a Catholic perspective, there could be something perhaps acceptable or even attractive in the idea. But I mean, even speaking as a non-Catholic, hypothetically, I'm not saying that's that is or should be the primary understanding, right? Like more broadly, I don't want to endorse like a voluntarist view of God or his commands. It's the idea that like God is all will and God could just as easily command us to murder as to not murder, and it's just whatever God picks out of a hat, or I mean, just to caricature. So I definitely don't want to. And even when I say that, like, for the purpose of, because what I want to say, the reason this all comes up in the book is like, well, what is legal obligation? Well, if we think of moral obligation as reason without commands, we think of we think of religious obligation as commands without reasons, and then somehow law is like you put those two things together, and that gets us closer to what law is. Even then, I am not saying that commands without reasons is certainly not the only or even the best or even the primary way to think about religious obligation, but I think it's a conceivable version of religious obligation that if we look at it, even without embracing it, can shed some light like structurally on what I'm trying to say about legal obligation. So I don't even want to go that far. Like I don't have anything at stake in convincing yourself that my beliefs or your beliefs fit into that model. And then the kind of the cute homiletic thing at the end is kind of suggest that like maybe there's like an interesting insight there, right? There's this, sorry, can I finish the sentence? Is it? Okay, sorry. Anybody needs to go like right on the dot, please feel free. I'm not rude at all because we're going over. But there's various commandments in Judaism that one can perform under an obligation to perform it. And there are also people who are not under an obligation to perform that who can perform it voluntarily and still get some kind of credit for it, like good thing to do. And you might think that intuitively the one who does it voluntarily is doing an even greater act because they don't have to do it. And yet there's a well-known authoritative teaching and tradition that the one who is commanded and does it is greater than the one who isn't commanded and doesn't. I'm like, well, like, what's the deal with that? Like, you did it because you had to, and you didn't have to, and you still did it. Like, isn't that better, right? Like, you're the guy who goes on to the irs.gov website and just makes donations to the Treasury, right? And I'm paying, that's like literally you can do that. Like, and I don't recommend it, but like literally you can, right? And I'm just paying my taxes, right? So how am I better, right? And so again, for this, I don't speak in the name of tradition, but I think like there's something there in the idea, like what does my required act have that your voluntary act doesn't? Obedience. Obedience to God. Yours is not an act of obedience to God. It's a great act. It's a supererogatory act, but it's not an act of obedience to God. And that's like something cool that you don't get the other way.
Great. No, and sorry, I forgot to say this first, but thank you for your talk. I really enjoyed it.
No, not at all. No, absolutely nothing to be sorry for. Yeah. Okay, because sorry, that's my mouse writing checks that my watch can't catch.
So my name is Larinos. I'm a senior electrical engineering student. So I've
heard enough for the engineers. Thank you very much.
I think this question probably would be answered in the first day of constitutional studies, which I didn't take. But where's with the conception of like authority not necessarily being with the people's consent, you can have a system that has authority without, and have it still be good without the people's consent.
Yeah.
How exactly does that fit in with the like authority of the Constitution on like our elected officials? How does that like all work together?
Right. Well, so yeah, I mean, maybe it's a question you want to ask about why does the Constitution have authority? Well, again, we voted for it, we ratified it. Well, how did we decide that ratification process was going to grant it authority? Well, actually, just by fiat, right? Like, I mean, even you want to go into American history, like there was they got together to revise the Articles of Confederation. Nobody conferred on anybody any authority to throw it out and start over, right? So you have these questions in a republic that was created and not just evolved, right? You actually have these questions, and I think even in a case of government by consent, I think we do kind of fall back on some of these. No, I think unavoidably, as I was saying, we fall back on the notion of the original unauthorized authority. Yeah. Okay, the natives are restless, so let's call it, and we can talk more after. Yeah. No, thank you, everyone. That was a lot of fun.